Okay. Welcome to the third session of the international webinar, Struggles for Recognition, Cultural Pluralism, and Rights of Minorities. Today, we are going to talk about animal rights and intercultural application of law. The order of the speakers will be first Olga ABELLO, second Vanessa PORTOCARRERO, third Giselle CARDOSO and Emerson COSTA, and fourth Monique Falcao, and Tiago Prado, Julia Roers, and Natel Gomez. Okay, the rules of the session will be the same as the other sessions. First, all the speakers will have a turn to talk. They have to expose their paper for 12 minutes, and then there is a turn for the discussion. Then the discussion asks questions to each presenter, and the participants answer the questions of the presenter, of the discussion. Sorry, the participants answer the questions of the discussion. Sorry, and then finally there is a open turn for other people, for the viewers, for the listeners, if they want to participate, if they want to ask any questions to the participants, to the speakers. And we are going to organize this, that there is an open turn, all the questions are asked. And then finally, there is a last turn of the speakers to answer all the questions that has been asked. Okay. I ask you that when someone is speaking, the other micro should be switched off, because the sound of the micros is you listen the sound of the micros while someone is speaking. Okay, then our first speaker today is Olga Lucia ABELLO RESTREPO. She's doing a PhD in Carlos III University. Her paper is called Cultural Diversity and Criminal Law Within a Context of Legal Pluralism, the Colombian Case. Olga, it's your turn.
Hello, everyone. Do you see my PowerPoint presentation?
No.
I don't know if you can see it. Now?
Okay, now. Yeah.
Okay, perfect. Wait a second, because I don't see it. Okay, yeah. Hi, everyone. I'm here to present to you my paper, which I called Cultural Diversity Under the Scope of Criminal Law, the Colombian Case. Well, I'm sorry, how do I change the... Okay, now. Cultural diversity has been recognized, the constitutional recognition of cultural diversity has become a challenge for most of Latin American countries with indigenous population. This is the case of Colombia, that has not only recognized this constitutional principle, but has also institutionalized a special jurisdiction for indigenous affairs. So, according to Article 246 of the Political Constitution, indigenous authorities can exercise jurisdictional functions within their territorial scope in accordance to their own legal standards and procedures, as long as they don't contradict the Constitution and the law. Well, the coexistence of different sources of law, in this case national and indigenous, and the different conceptions between universal and particular conceptions of human rights have led to the occurrence of different cultural conflicts that have a huge impact on human rights. Well, it is in the criminal law arena where these conflicts or these tensions become more defined, as this branch of law has been entrusted with the protection of the most precious legal assets for human beings, such as life, personal integrity, human dignity, among others, resulting quite challenging for the hegemonic society to reconcile these prerogatives with the interests of the minority groups. In that scenario, this intervention will be focused on answering the following questions. So first, Should the cultural element have a special consideration in the determination of criminal responsibility? And second, which treatment should criminal law give to the behaviors that, despite being prohibited by the hegemonic legal system, are accepted or even approved by culturally differentiated groups? Culture, as a set of symbols that guide human perceptions towards the outside world, has a definitive influence in the normative production process and in the determination of people's behavior. So, according to Volt's group conflict theory, criminal law is no stranger to cultural and social reality. In fact, the content of legal norms is determined by the hegemonic group in detriment of the minority groups who have no voice or vote in the normative production process. Similarly, Mayer has grounded the obligatory nature of law in its correspondence with a special type of standard that is recognized and accepted by everyone. So he talks about the cultural norms. According to the author, a law that is alien to culture can't stick in the legal system for long because each person is judged according to the standards whose mandatory nature has been recognized. These approaches are very important in the study of culturally motivated crimes because they lead to question if culturally differentiated groups are bounded to obey the legal system that has been imposed by the hegemonic group, or if there is some kind of cultural justification that excludes them from their compliance. Another consideration to take into account in the study of cultural motivated crimes, wait a second, I think my video went off. Okay, yeah. Is the influence that culture has in people's behavior. So on this regard, Parek has referred as people to cultural beings that cannot transcend from the cultural sphere because as thinking beings, human beings act according to a perception of the world that has been molded by culture. In that same sense, Silva Diaz has explained that the enculturation process is the assimilation of cultural traditions and cultural practices through which people build their own identity. Since culture has a definitive influence in the normative production process and in the determination of people's behavior, it is substantial that in criminal law arena we take into account the cultural element because the principles of equality and culpability demand a particularized justice that is sensible to cultural differences. The concept of culturally motivated crimes has emerged in the context of cultural conflicts that take place in the criminal law arena when the hegemonic power criminalizes behaviors that are accepted or even approved by culturally differentiated groups. The need to differentiate between this type of crimes and ordinary crimes that are committed by minority groups has led to condition its configuration according to the following requirements. So first, the behavior should be carried out by a person that belongs to a culturally differentiated group. Second, culture had a decisive influence on his or her decision to commit it. And third, it can be verified that the other members of the group would have similarly reacted to a given situation. And fourth, there is a contradiction between the minority culture and the hegemonic culture. Well, in Colombia and most of Latin American countries with indigenous population, the legal system has evolved from the forced assimilation of indigenous people to the recognition of their individual and collective rights. In the criminal law arena, two proposals reflect this evolution. So first, the non-criminal liability for the culturally diverse parts from the consideration of indigenous people as incapable beings similar to infants and people who suffer from mental insanity. Because they can't understand the illegality of their criminal behavior, the law excludes them from any criminal liability, and in the context of Colombia, the criminal code used to prescribe that the judge must reintegrate the defendant to their cultural environment in accordance with the authorities of their community. On the other hand, the culturally conditioned error prohibition that was developed by the Argentinian author Zaffaroni as a new approach to the traditional error of prohibition figure parts from the consideration of the defendant's impossibility to knowledge the illegality of their criminal conduct due to a cultural background that makes it difficult or makes it impossible for the defendant to internalize the values that are behind the legal system that has been imposed by the hegemonic society. In such cases, the judge will have to define if the error was beatable or if it was invincible. So, in the first scenario, it leads to the graduation of the punishment according to the defendant's level of internalization of the legal system. And if the error was invincible, it leads to the exclusion of culpability. The Constitutional Court of Colombia, in sentence C-370 of 2002, decided that the first proposal that was reflected in Articles 33, 69, and 73 of the Criminal Code were discriminatory because they were based on the psychic inferiority of culturally differentiated groups, and because they created a different treatment between indigenous people and other culturally differentiated groups who don't have their own authorities nor a defined cultural environment to which the defendant could be reintegrated to. In that sense, non-indigenous culturally differentiated people like migrants could benefit from the traditional figure of error prohibition that was prescribed in Article 32 of the Criminal Code. So in case the error was invincible, the migrants would be excluded from any criminal liability. But instead, indigenous people would not only be considered psychologically immature, but would also be forced to be reintegrated into their communities. Despite recognizing that Zaffaroni's proposal was was less invasive criminal regulation, the court decided to maintain the first proposal. By this, I mean the non-criminal liability for the socioculturally diverse, but under the consideration that this figure doesn't derive from a mental incapacity, but from a different worldview. The court also decided to exclude the security measure that consisted in the reintegration into the natural environment because it contributes to penalizing cultural diversity. So, under the current regulation, criminal behaviors that are committed by indigenous people could lead to the exclusion of criminal liability if being invincible, or to the configuration of a liability without criminal consequences if being beatable, since the rule that established the security measure of reintegration to the cultural environment was removed from the legal system. So even though this sentence advanced towards the decriminalization of cultural diversity, it maintains a negative connotation against indigenous people on account of their culture, and also by maintaining a kind of liability without criminal consequences. This sentence contradicts the principles of equality and legal security. In my opinion, Zaffaroni's proposal is better in achieving the simultaneous protection of cultural diversity and protection of individual rights, since it differentiates between invincible and beatable error of prohibitions, allowing the judge to graduate the punishment according to the defendant's level of internalization of the legal system imposed by the hegemonic society. Without a doubt, this way of solving culturally motivated crimes is the most adequate in the context of Latin American countries with immense population, because it allows integrating the cultural factor in the determination of criminal responsibility without sacrificing the prevailing social values of the hegemonic group. So thank you very much for your attention. I'll be happy to hear all your opinions and questions about my presentation.
Thank you very much, Olga. Very interesting paper. And now is the turn of Vanessa Cuentas Portocarrero from the Pontificia Universidad Católica de Perú. The paper is titled is The Need of Incorporating an Intercultural Perspective for Applying Petrial Detention. Vanessa, it's your turn.
Hello, is everybody hearing me okay?
Yes, we are hearing you.
Great. So my name is Vanessa Cuentas. I am from Lima, Peru. And I'm going to talk about the need to incorporate an intercultural perspective in the application of pretrial detention. Notes from the Bawasso case. My interest in this theme is because during the Bawasso case, there was this person, Feliciano Kawasa, who spent 5 years in pretrial detention without a definitive judgment that declared him guilty of any crime. He was a member of an indigenous tribe, which is called Wampis. When the oral hearings finally began, it was decided by the court that he would be placed under house arrest. However, as a member of an indigenous community, Feliciano did not have proper address by the standards of the ordinary justice, which led to the court to decide that he would be put under custody in a small property in the city of Bawa. He was alone and unable to leave the property or to receive visitors. He was in prison, although he was not in one. So my exposition will be divided in 3 parts. First, I will tell you about the Bawasso case and what happened on June 5th, 2009. Then I will be examining the pretrial detention from a human rights perspective, which will include a review of international standards, and that specifically is applied to indigenous people. And finally, based on the concept of interculturality used by Giselle, I will be re-evaluating the pretrial detention of Feliciano Kawasa. So, about the Bawasso happened on June 5th, 2009, when the communities Wampis and Awajún, which are 2 indigenous people who inhabit Loreto and Amazonas in Peru, decided to block one of the main roads in the jungle, in the Amazon. This happened because one of our ex-presidents, Alan Garcia, decided to sign multiple free trade agreements with the United States, which included exploitation of the lands where the Wampis and the Awajún lived. The block of the road lasts through March 2009 to June 2009. And during those months, there were multiple attempts of dialogue on both sides, and even agreements were signed so that the tension situation will end. However, they wouldn't reach an agreement. And on the morning of June 5th, the police received the order to attack the indigenous people that were on the road. They began to fire rubber bullets to them. And as a result of the confrontation, there were 33 people dead, 12 policemen and 21 natives. Many more were injured, and 55 people were arrested in flagrancy. 55, which 50 were members of indigenous tribes, either Wampis or Awajún. And the other 5 were what we called mestizos, which are residents from the area who do not identify themselves as indigenous, but they were they supported the ideas of the Wampis and Awajún. The Bawasso, what happened on June 5th, on June 5th, led to multiple criminal procedures. There were open 7 criminal procedures because there were multiple acts that took place on that day in multiple areas of the Amazon. But there's only one sentence, one final ruling about the events of that day, that it's the Bawasso case. So in that case, which began on June 5th, the investigations lasted 5 years. During those 5 years, Feliciano Cawasa spent his days on prison in Chiclayo, which is another province of Peru. And he was unable to receive visitors because the prison was very, very far away from his community. So he was alone, and he did not receive the support of the state. So about pretrial detention in the case of indigenous people, pretrial detention is very problematic in our region. We have approximately 40% of people in the I'm so sorry. Let me. 37% of the total number of people incarcerated in Peru are in pretrial detention, and there are similar percentages around the Americas. In terms of limiting the right to freedom of indigenous people, Article 10 of Convention 169 of the International Labour Organization is clear. It is necessary that any criminal sanction that is imposed must take into account its economic, social, and cultural characteristics of indigenous people. And alternative penalties to incarceration should be preferred. There is no specific rule on pretrial detention, but it is possible to affirm that the same rule will be applied for the precautionary measure, given that the necessary examination could only consider a penalty other than confinement, and that the precautionary measure cannot be more burdensome than the penalty. For its part, the Inter-American Commission on Human Rights mentions the need to incorporate a differentiated approach in the application of pretrial detention to the indigenous population, as they find themselves in a greater situation of vulnerability. Unfortunately, there is little information on the specific problems faced by indigenous people who are in pretrial detention in Peru. In fact, it is only since 2016 that there is information on how the prison population ethnically determines itself. The first prison census showed that about 25% of the total prison population self-identified as a member of an ethnic minority. However, there are experiences in the region that provide an overview of the peculiarities of pretrial detention for the indigenous people. For example, during 2018 in Chile, a pretrial prison order was issued in 1,135 processes where the person investigated was indigenous, which represented 12.6% of all cases with indigenous defendants who were in charge of a public defender. In the non-indigenous, on the other hand, the proportion was only 7.4%. Another study in Mexican states of Oaxaca and Chiapas, demonstrated the excessive use of pretrial detention when it comes to indigenous population. Of the total number of indigenous people incarcerated in Chiapas, 52% maintained the status of accused, while in Oaxaca, this percentage reached 97%. The three studies mentioned emphasize the effects that pretrial detention can have on the indigenous population, especially considering the remoteness of the penitentiary centers from their communities. This naturally generates a process of abandonment by the family and the community, to which must be added the aggressiveness of a justice system that is not their own. So, having carried out an account of the facts, the case, and the scope of preventing detention as a possible violation of human rights, it is necessary to address what happened with Feliciano Cawasa with the tools provided by intercultural analysis. First, the concept of interculturality that will be used will establish, that will be established, and then it will be reviewed within the dominant justice system, specifically in the imposition of preventing detention. As I mentioned, interculturality starts from the factual fact that diverse cultures exist, that interrelate with each other and generate links that have the capacity to vary over time. Since relationships may have tendency to inequality based on historical factors, it is necessary that the interaction between the two starts from respect, which will be promoted. The need to make such relationships equitable in order to achieve recognition, as said by Tubino. For her part, Catherine Walsh seeks a critical stance on interculturality. It is understood as a permanent strategy, action and process of relationship and negotiation in conditions of respect, legitimacy, symmetry, equity, and equality. But even more important, it is understanding, construction, and positioning as a political, social, ethical, and an epistemic project of knowledge and knowledge, which affirms the need to change not only relationships, but also structures. When transferring interculturality to the legal sphere, it is usual to find the term legal pluralism, understood as a recognition of more than one system of valid norms, generally divided between the positive and the customary norms. It is usually because, as a result of intercultural relations, the legal decision system that is respected and set culture is known and renowned. Although in Peru, there is a recognition of pluralism. For example, we have what we call rondas campesinas, jueces de paz, which are selected by the community in base of multiple factors, but they have the power to give decisions. But as it was reported at the beginning, the conflict of Bawasso originated from cultural differences regarding the perception of the land and its property, and due to the non-compliance with the state obligations of Peru. It was this shock that originated the confrontation that led to the violation of the fundamental right to life, and therefore the activation of the dominant justice system in accordance with the provisions of the Constitution. In this sense, that will be sought in the following lines is to evaluate the elements of preventing detention, considering interculturality as one of its guiding principles. So, pretrial detention has three presumptions analysis. The first is that there are well-founded and serious elements of conviction that led to the high degree of probability that the person under investigation actually participated in the criminal acts that are imputed to him. In the case of Feliciano Cawasa, he was charged with homicide against the 12 police officers who died on June 5th. According to their autopsies, they died from injuries caused by firearms. And Mr. Cawasa, according to the police, was detained at the scene with firearms. But when he took the atomic absorption test, it was known that he did not have fired any weapons that day. The second presumption of pretrial detention is that the sentence that is probably being imposed is greater than 4 years. In this regard, it is necessary to mention that the question of whether or not to proceed with pretrial detention generally occurs at the initial moments of the criminal process. When investigating a criminal act committed by an indigenous member of an indigenous tribe, this can cause difficulties, as there cannot yet be an accurate classification of the fact, which considers all the elements of the type. This will be one of the first points that will have to be considered in an intercultural analysis of pretrial detention, given that there is a degree of probability that the act will finally be classified as a culturally motivated crime, and therefore not subject to punishment, in which case the second legal budget would not be met. It was procedure that was finally used by the chamber that resolved the case in the first instance, although it would be unnecessary with respect to a crime of qualified homicide imputed to Mr. Bawasso. Finally, the last consideration about pretrial detention is the reasonable indications that a person may be in danger of escape or danger of obstruction of the process. About the danger of escape, this one was one of the main elements that were taken into account in Mr. Bawasso's case, especially when the court noticed that he had been past the maximum time to be in pretrial detention, which is 36 months in Peru. So the court took into specially account that he didn't have a domicile element, which is usually verified in our DNA, in our national identity document, and seeks to be certain of the exact location of the person, so that the state can exercise its coercive power to go looking for it if it's necessary. As a member of an indigenous community, the name of the community appears in the section address of the DNA of Mr. Bawasso. This is where it's imperative to incorporate an intercultural perspective. Under the standard of the dominant justice system that manages a domicile, there will be few indigenous people who can comply it, given that many of them belong to nomadic communities, which have a direct link with the land, but move through the territory depending on issues like the seasons of the year and their survival. If the intercultural perspective is not included in the analysis of pretrial detention, it is highly probable that indigenous people who have to face a pretrial detention hearing will eventually be imprisoned and therefore isolated from their communities, leaving them in greater state of vulnerability to a system that aligns to it. If an intercultural interpretation of domicile that contributes to protection of the process is not possible, as long as there is no domicile per se, but there is an indisputable link with the territory, then it is necessary for legal operators to be able to incorporate control mechanisms by or linked to the communities. For this, it will be necessary to use the same tools that are used when examining whether an action can be categorized as a cultural motivated crime or not. And I am talking about anthropological expertise. At this point, it will be necessary to carry out an intercultural dialogue based on legal pluralism, in which justice operators share and coordinate. Only in this way, it will be possible to speak for a real incorporation of the intercultural perspective in justice systems. Thank you very much. I look forward to hearing all your questions, if you have any.
Thank you, Vanessa. Thank you for your speech. And okay, now we have another presentation, another paper on animal rights from Giselle Maria Custódio Cardoso from the State Environmental Institute, Rio de Janeiro, and Emerson Affonso da Costa MOURA from the Rio de Janeiro State University from Brazil. And the paper has as a title, Analysis of Non-Human Animal Status at Urban Area Through the Biocentric Paradigm, Institutionalizing a Representative Mechanism to Provide Recognition to the Animal as a Subject of the City. Okay, it's your turn.
Thank you very much, Professor. Hello, everyone. And good afternoon for those that are here in Latin America, and good evening for those that are in Spain. It is a great pleasure to be with you today here, and also a great honor. I also would like to congratulate the organizers for this amazing event, and specifically for this session, acknowledging though the importance of this topic. So, as Professor Oscar previously presented, I'm here today with Emerson, and we intend to present you part of our master's research that we've been developing together at the university. Basically, our main idea here is to share some of what we are achieving so far, in order to present you a mechanism for representation of non-humans at urban centers. And it's interesting to think about the urban centers in general, because you're probably aware that half of the world population lives in the urban centers. And according to UN prospects, we will continue to grow for the next 30 years in urban centers. So if we already have problems now, if nothing will do about it, and if we don't start to think about it, problems related to our species and also related to the non-humans that lives in the urban centers nowadays without a proper regulation and a proper protection under law, it is of course that the problems will only increase. And that's why we understand that it's such a relevant issue. So the main pillars of this research are the contractarianism theory, classical and broadened by the capabilities approach of Martha Nussbaum, the biocentrism related to the sentience, and also guardianship. You know, probably some of you are thinking that why contractarianism? So, as Nussbaum says, this is such a relevant theory, and basically our modern society, our social, legal, and political structures were built based on the contractarianism, based on the social contract. So it is easier to manage and deal with something that we are already aware and familiar with than just destroy it and comes up with something totally new. I know that it is very beginning. It was a very strictly theory just for free, equal, and independent individuals, like Rousseau used it to say, and also a very rational individual, according to John Rawls in his Equity as Justice theory. But also this idea of theory that is so relevant for the social justice and for all of our systems and structures, lead us to deal with it and in such an easier way. And it's interesting because Rawls identified in his theory 3 unsolved problems, like the disabled, the foreigners, and the non-human animals. And Martha Nussbaum reaches these 3 unsolved problems and thinks, well, we have a theory that built our society, and we have groups of individuals that aren't able to be included. So what we can do about it? Well, we can broaden it in order to include them. So based on that, she starts to develop her capabilities approach, which was developed in economics by Amartya Sen and in philosophy by her, which basically is this guidance for the governments of all nations, include in their regulations, in their constitutions, this core of human entitlements in order to have a bare minimum in regard of the human dignity. So having at least this, and she creates a capabilities list, we would have at least this capabilities to guide the governments in order to guarantee a dignified existence for those groups of individuals that were unable to be included in the social contract. And also, along with the capabilities approach, she achieves this principle called paternalism principle, raised by John Rawls, and he stated this principle just to shape his theory, basically adapting that the individuals from this generation could choose the principles of justice for the individuals of the next generation. This in his theory, but to us, it is a representation inside the contractarianism about the representation of this mechanism of representation, because it is basically one individual that is would be able to choose on behalf of another one, and aiming this and having this as a structure, we can adapt the contractarianism, we can adapt the capabilities approach and broaden it to bring this recognition for non-humans as a subject of the city. So, having this idea together, we add the biocentrism as a scientific justification, because in the 70s, Rawls recognized that animals feel pain and pleasure, mostly pain, and that's why we had to have compassion towards animals. But after the Declaration of Cambridge Unconsciousness, and also after all of these theories like the utilitarianism from Peter Singer, and also the theory of the rights by Tom Regan in philosophy about the non-humans, we have science on our side saying, yes, they feel pain and pleasure. So not only we have to have compassion, but we have to have moral duties towards them. That was something that Rawls wasn't recognizing, didn't recognize it back at there. And that's why we add this element in order to turn this guardianship and this mechanism of representation reality in our society. And Emerson will delve into it a little bit more. I'm just presenting you the basic pillars of our research. And so, assuming that guaranteed representativeness for non-humans would also assure life with dignity and the recognition of them as the subject of the city, we are now developing this idea and sharing with you today. And I am pretty sure that we'll have a lovely session here, and I also look forward to listen more to you and share more of this with you. Muito obrigada, and thank you very much. Emerson, it's up to you.
Emerson, we don't hear you.
Oh.
Emerson,
okay.
Is going to talk or no?
Yes, can I go, Professor?
Yeah, of course. We don't
Thank
hear you. The micro was switched off.
Oh, thank you. First, I would like to thank the Professor Oscar and all the involved here in this event. Also, I wanted to congratulate Giselle for the very impressive manifestation here. I would like to talk about the professionals that are here from Brazil, Professor Pedro, and the other students of Master of Law in the University of States of Rio de Janeiro, Gustavo Campos, Paulo Brandão, and the research Elise Dijane that's also here with us. Like Giselle said, the paper we're gonna to study is part of her study in the Master of Law of University, and we're gonna try to investigate a new dimension of protection of the animals, or better, the living beings here. Also, try to understand the paper of them like subjects on the city. So I'm going to talk just a little bit of some appointments about them that Giselle already lets me talk. And the first one is initiated by a problem that is the problem not about only philosophy, about the paper of animals like moral beings, with the protection of her feelings, her desires, her frustrations, but also a problem that comes from economy, the search of natural resources, and the effects in the planet, and also a problem of law. There is a problem of the inability of the to try to protect the animals here in Brazil, like we're gonna say after this talk. So this crisis try to one need of a new mechanism of protection the animals and protection the human being, like a conception not only individually, not only as a person, but also as a part of the nature, and the need to recognize the limits of the human have as parts of nature, like we're gonna see now in the pandemic of COVID. So this changing of a view inserts in a new movement. We like to say a new constitutionalism, Latin America, who try to create a new forms of states, like a pluricultural states, who will protect the diversity of society, but also we protect the identity, the culture, and the other forms of subjects in the political order. Of course, this new movement is also very clear in another countries like Bolivia or Ecuador, but here in Brazil we are more limited because the constitutional we have, they the text try to search social rights, try to search social justice, but in the moment they're gonna to try to regulation the nature, they don't regulate the nature as a subject, but as object. So we have a protection of a man without recognizing of your interaction with nature, like we have in another countries of Latin America. And the problem goes with the protection of animals, because traditional, the law will protect them like not a person, not a subject, like an object of the law relation. So we have the Constitution only trying to protect by not by guarantee not cruelty in the treatment, and also we see in the law of ambiental crimes some punishment by abuses of animals, and we see like in the civil code when we see the obligation of the owner of the animal to pay for the damage that he caused. In the last years, we have a growing up movement to try to protect the animal like not an object, but a subject. But we don't see these protections. I don't know if Giselle agree with me, but we don't see this protection in a way so good like it should be. Because o Superior Tribunal de Justiça, the of Brazil, try to protect those animals, still don't recognize him as a subject. I'm going to give you by example. We have recurso action who says that the owner of the animal, even if with him some
I don't know the other people, but
could you listen to me?
Well, I had some problems. Now I hear you.
Oh, thank you, Professor. In another decision, the Supreme Tribunal Federal, our constitutional court, says that the vaquejada, a kind of game with animals, will not be allowed because the problems with the health about the animals, but nor in any vote of the Supreme Ministers we have a consideration of the animals as subjects, but only we have to protect them and apply the constitutional when forbid this kind of treatment. And we have more recently a decision about a law, a state law, who was forbidding the death of animals in religion rituals. And the Supreme Tribunal Federal, our constitutional court, was say that animals could be, in matter of fact, be dead for the regular exercise of religion freedom. And so we still have a problem in Brazil to recognize those animals as subjects. And this is a problem because, like Giselle said, not only in Brazil, but in all of the world, we have the most part of the population living in cities. And so we try to construct, in special in these matters of law by University of States of Rio de Janeiro, the idea of a right to law, a right to city. I try to construct an idea that the city is the form of the people and the subject that the capital already puts in the position not equal to achievement and access the goods of the city. So the law of the city is some form of justice, a social justice, who's going to bring a need to protection not only for the persons who are the human persons who are in such position, but also the animals who represent a number, expressive number of the subjects here in the city. The object of the paper is try to give them protection and promotion who recognize the paper then in the city and the construction of a city for animals too. Those was my manifestations. Thanks again. Obrigado a todos. And we are here to answer the question. Thank you.
Thank you very much. Well, now is the turn of Monique Falcao, Natiez Gomez, Tiao Brado, Julia Roers from Santa Úrsula University. The title of the paper is Animals as Minorities, Some Theoretical Critics and Contributions. Is your turn.
Yeah, thanks a lot. I will make a very small introduction only to present ourselves, and then Tiago, Julia, and Natiele will each present a small part of their studies. So I am a professor and researcher at Santa Úrsula University in Brazil, and we have this research group called City, Law and Sustainability. And so in this research group, we are actually now working on animals' rights, even because we are linked to the Ethics Commission for use of animals in the university. So that's why we have this research group, and the students, they take part of this and they work on it. So this work is a work, this paper is a paper made by students of graduation. Yeah, this is not master, this is not doctoral, this is a research that we do in the course Faculty of Law. So this is just the small introduction I'd like to make. And so that's why now I ask Tiago, Julia, and Natiele to each present a very small part of what they study, and then after I will talk a little more, explain a little more the project, and I'll also answer the questions. Yeah, that's only this. Thanks a lot.
Am I sharing the PowerPoint?
Yes, please, Thiago, if you can share the PowerPoint, I would be very thankful.
Can you see? No.
Not yet? No. Yes, now yes. Not yet? Now yes.
Okay.
Okay, it's quite simple. That's okay, really.
Oh, sorry.
No, it's okay. Really, it's okay. Just simple, just to show it and then go. So.
I think you're not. Sorry, I guess I can't to share because I need to open other.
You need to upload the file.
Paper here.
You need to upload the file to the Blackboard. You need to upload the file. Agregar archivos. Compartir archivos, agregar archivos.
Okay, archivos.
Okay, this is typical of being on live.
I guess I got.
Yeah.
Yeah. The Brazilian Constitution. Sorry, I can. Okay. Sorry for confusion. Yes. The Brazilian Constitution expressly protects protection of fauna in Article 225, paragraph 1st, item 7. It expressly prohibits practices that subject animals to cruelty. However, the practical applicability of this device finds limits historically built on economic and scientific functions attributed to domesticated and wild animals. On the other hand, this device has expanded its applicability to prohibit activities considered disproportionately cruel and violating animal and human dignity, based on values such as repudiation of violence and civilizing progress. A quick and intuitive indication of the different treatment given to protect and no protect animals by Article 225, paragraph 1st, item 7, are the jurisprudential annotations of the Supreme Court linked to this provision in its jurisprudence repository for purposes of interpretative guidance and concrete application of this provision by law enforcers. The judges listed there define cruel sports and leisure activities historically seen in Brazil as cultural in certain locations. Jurisprudential analysis of animals used for scientific, food, and other economic uses are excluded from this repository. One reason may be that such cases did not reach the Supreme Court. Another reason may be that they arrived and were not elected by the STF itself as deemed relevant on the subject. This investigation will not be object of this paper, out of it touches some question of this work. In any case, what has been referred to as a cruelty in Article 225, paragraph 1st, item 7, are the farra do boi, in English, Bing of the Ox, the Rinhas de Galos and Rinhas de Cães, in English, Carols of Cocks and Dogs, and the Vaquejada.
Yes, I can hear anything.
Now it's Natiele's turn. Natiele's turn. Natiele? I guess she has some problem with the microphone. So I will ask maybe Tiago to go on and read Natiele's part, please.
Okay.
Thank you.
The research project presented in this paper takes this framework as object of study and aims to think the contribution of civil society to emancipation or resignation of animals' legal status in the last decades in Brazil. The elected cases have the peculiarity of having been filed or of having a massive participation of civil societies sectors, such as a mixed jury or in public hearings. Two preliminary observations allow us to develop this project. First, the basis for declaring this practice unconstitutional. Sorry. In this field, we will present the critique of anthropocentrism as a principiological normative foundation for the definition of cruelty as disproportionate in favor or recognizing the wisdom of animals. This perspective is historically closer to recognition of animals as subject of rights and more distant from the traditional characterization of animals as an object of law. Second, the role of civil society is as a voice, interlocutor, and instrument of struggle in favor of these animals. In this field, we will take theoretically and methodologically animals as minorities based on the operational concept new social movements.
The dialogue between these two fields will be possible by recognizing civil society is an open society of interprets that, in the organized way, consolidate values and demands materializing is real power factors of the Constitution. Our hypothesis is that even if the text of Article 125 remains unclear, its meaning and applicability are muffled, being these real power factors that underline the waning of the application of deviance and the progressive redefinition of the legal status of animals. This is constitutional mutation. The characterization of animals is minorities, taking already consolidated literature for the defense of animals' rights. We allow us to deepen theoretical and practical aspects of the characterization of animals as social actors of historical subjects. This approach is the juridical philosophic deepening of the critique of anthropocentrism is normative nuclei of constitutional principles, and the socio-political game involved social actors and historical subjects in historical cultural process. Our future stage of research by our research group in the paper will gather on the society premises the allows to present the initial development of our primary hypothesis.
Thanks a lot, Tiago and Julia. So I will just explain a little something. When we actually, okay, I'll try to turn on the video. Yeah, sure, so you can know who I am. Yeah, okay. I feel sorry for that. Hi, yes, that's me. So, okay. So that's the point we are trying. This is a project for graduation students. It has interdisciplinarity with the course of medicine, veterinary medicine that we have in Santa Ursula University. And actually, we have these big three parts. So first of all, we decided to take these decisions from our Federal Supreme Court because, okay, it was just a start point. Yes, because this field of animals' rights, it's really big. It's very large. So we don't, we have many different kind of functions of animals in society and in economic practices. So that's why we just take the first one. And what we could see is that on the website of our Supreme Federal Court, there are official repository of jurisprudence. They, in the article 225, paragraph 1, number 7, they have only, I would say like this, only decisions about this these animals used in sports. So the cockfighting, the dog fighting, the oxbing, and the vaquejada that our colleague has already talked some about it. So we just took these decisions, and these decisions, they are basically about using animals in sports, economic activities, more sports activities. So this is a very small framework. Yeah, this is a very small, how can I say, cut. Yeah, that to build this empirical object. So this is very small, and that's why we took it. And what we could see is that we have in the last 20 years since our last constitution, we have much more the people asking, the civil society acting in defense of the animals. So we are working with these categories: the constitutional mutation, yeah, because it is an informal process to change the meaning of the legal text. We take just this simple, very simple definition of constitutional mutation, because all the philosophical theory behind this we will work after, because this is only a project. And we also think that take the constitutional mutation as the aspect of change application of law, keeping the same text. This is interesting because these allow us to go a little further, to link this with the open society of interpreters and the sociological sense of constitution from La Salle. That's another operational concept that we are working with. And so how can we work this a little deeper is that when we look to the open society of interpreters of La Salle, we can go a little deeper to think, for instance, in a sociological field, we can think the new social movements. And I'm working here with GON, and also if I go a little further and a little deeper, I can work with Touraine and with Dubar and with French school sociology, that they work a lot, the rebuilding of the social actors, the rebuilding of the historical subjects, yeah. So they allow us to think, to measure a little like this in a qualitative way, not in quantitative way, but in a qualitative, how the civil society can impact the emancipation of animals, I would say like this, and the rights of animals, yeah. And when we take the meaning of animals as minorities, I'm just taking the what is already done by the literature for animals' rights. So I take the classic authors to start, and I take them as a start point. I will not criticize them in the first moment. We will only take them and to make the comparison between, for instance, they say that the specism is only another species of this kind of prejudice that we had with racism, with the sexism, and also with the ethnocentrism, for instance. So if we just think the animals as minorities, for instance, I'll take this start point to think that the already known literature say to us is that they make an analogy, the specific with the racism, because it's based on the prejudices based on the appearances, the sexism because we have the difference between, for instance, the white man and the masculine and the others, that would be, for instance, the woman and the other things. And also, they allow me also, just a moment, I don't want to get lost. Yeah, so the principal, the mainly elements I have are that we think the minority, like the victims of discrimination and prejudice, in the perspective of ideology with while domination are three elements: economic exploitation and competition, unequal power largely vested in control of the state, and ideological control. So these three, they are very interesting because they deal with the critiques that are made to the anthropocentrism. Yeah. Okay. So this is one thing. And okay, our goal or our objective, as I said, is to take the new social movements because they are quite different from the classic ones. I would say like that. And I'm taking here our Maria Gon. This is a Brazilian researcher. She has a lot of studies in this field. And so the new social movements, they would be much more participatory, decentralized, spontaneous, and fluid than the classic ones. They have a small disappointment with civil society, with the tradition participation practices. So that's why they are much more informal organizations to reivindicate some other rights for some other groups. And there's something interesting that the reivindication is made normally in the name of other groups. That's quite interesting. The reivindication for change of mentality and not to change the infrastructure. Yeah, just like it's not to change, for instance, to finish the capitalism to start the socialism. No, I want to have the capitalism, but want to be included on it. So that's one thing. And this is interesting also because there are the voices come from collective groups, and it's like it's not only who suffers the prejudice that reivindicates, but it's a reivindication from the whole society or groups of society asking for change of mentality. Yeah, and so this is that there are our mainly how can I say criteria and operational concepts to work this project. Our goal is to investigate the contributions and the limits of the civil society to emancipate the juridical status of animals. So that's one point. And this work for this paper, we decided to take, for methodological reasons, of course, they said, because the animals' rights are a very large field, so we had to make a very small cut. So as experience to make an hypothesis, we decided to take these three decisions in STF, our Supreme Court. But we have larger goals. For instance, we'd like also to think about the paper or the impact of independent protectors that we have in Brazil. That's something, for instance, that's not so much common in Europe, not so much common in the United States, but it's very common in Latin America. And we also have some informal networks of people that rescue animals and domestic animals on the street. Yeah, so for these people, we want to have a special look. We want to have a special attention because these informal networks, they are very, I would say, inside themselves, they are very powerful because they make a very great work. Yeah, they don't ask anything to the government. They don't ask anything from big companies. They just have their own work and their own resources. So it's quite interesting also to think about. But they are a different kind of field, different kind of framework, but it's also important. So that's it. I thank you a lot, and yeah, that's it. Thanks a lot. Bye bye.
Thank you.
Thanks, Oscar. Sorry for the mess, but yeah, thanks a lot. Good.
Okay, well, now is the turn of the discussion. I am going to ask some questions to all the participants. The first one, it was Olga ABELLO. Okay, what do you think of the different judicial rulings who establish gender violence as a culturally motivated crimes, for example, in the Chilean indigenous communities? And what is your view on the improper rape crime within indigenous communities? Improper rape is it's a situation in which there is sexual relationships with a person who is under certain age, and although is with consent, is a rape according to certain regulations. Okay.
Okay, thank you, Professor, for your important question. In my opinion, in general, group rights can't be protected in detriment of individual rights. So, in my concept, the concept of the right to cultural diversity is not limitless, and sexual freedom and human dignity, among other human rights, should prevail in case of collision. In fact, the Constitutional Court has considered that cultural diversity is restricted by some intangible minimums that are product of an international consensus. So here in Colombia, for example, life, the principle of legality, the prohibitions to slavery and torture are restrictions to the right to cultural diversity. I think, well, I propose to overcome the so-called multicultural vulnerability paradox that has been exposed by the author Shashar. This paradox provides that well-intentioned efforts of protecting cultural minorities could end up harming the most vulnerable members of the group. So to overcome this paradox, I propose to reinforce the role of women in intercultural dialogues and to acknowledge that women are in a situation of double vulnerability. First, because of their gender, and second, because of their membership to a minority group. So knowledge that they require special public policies for the protection of their particular needs. But in general, I think that the cases of improper rape, crime, the proposal of my paper is to take into account the cultural element in the determination of criminal responsibility. But obviously, this right has limits that should prevail in case of collision. So thank you for your question.
Yes, well, I have a paper on culturally motivated crimes. I think you are an interesting institution, but the problem of culturally motivated crimes is that the common example has women and children as victims. And well, if we are going to punish less, and the victim is a child or is a woman, maybe we can think better if we apply a culturally motivated crime. No, that's my conclusion. No? And I think we agree on this, Olga.
Yeah, I think that we agree, and the error prohibition, for example, allows the judge to graduate the punishment according to these special circumstances. So I think that is very important to take into account culture in the criminal in the determination of criminal responsibility, but with restrictions provided by human rights.
Yeah. Okay, then my questions for Vanessa. Hello, Vanessa. Okay, your paper is interesting, is something new, is connected with a previous paper about culturally motivated crimes. You talk about the petrial detentions. Okay, the first conclusion is that law is not neutral for minorities. That is the first conclusion of your paper, I think. And you ask, I think in the conclusion, in the final part, you ask for an intercultural interpretation of the law. If I understand well, okay, first, the pretrial detention of 5 years is a crisis of the judicial system, is a problem
Yes.
of the system. This is, we agree on this. But I am going to be I am going to ask something controversial, I think, because you ask for an anthropological interpretation or anthropological intervention in order to analyze how the communities deal with certain situations. I am going to be a bit controversial, I know, but I would like to ask, because this case is very well received in my classes with Latin American students. I am talking. Okay, my question for you will be, what are the intercultural alternatives to the pretrial detention? And I put the example. Okay, what do you think about the fuete, the whip punishment? What do you think about the indigenous communities punish the people? Punish with the whip, with the fuete. Fuete is a very famous case in Colombia. Okay, you are in favor of this intercultural interpretation of the law, or do you think pretrial detention has defects, but it's a better solution than the whip?
No, I'm not for the whip. I think that I may have to reconsider the final part, because it's not my understanding that it's for that. When I say that that we need an intercultural dialogue between both systems, the regular system, the communal system, and the system in the indigenous community, I am talking about when I have seen cases, not exactly the Bawasso case, but when I have had the opportunity to talk with judges within Loreto and Amazonas, which are departments in which there are communities. They have talked to me about two kinds of cases. The first case is in a case when the subject has committed a crime that has shocked the community, and it's going to be exiled from the community. That's the punishment from the community. So in that case, you couldn't have intercultural dialogue in which you have the pretrial detention within the community, because the community has already exiled this person. But in the case, if the action committed by this person isn't a crime within the community, which is the case in the Bawasso, because they didn't think that they were committing a crime. They were just making themselves heard for the whole situation about the TLCs, the agreements with the United States. In this case, what I am pretending to say is that you have to meet somewhere in the middle, not a physical punishment, but maybe if the person is put in custody, not in the city, but within the community, yeah. like a guardian in the community, and it would be like the head of the community, maybe, which is the person who takes all the sayings and the do's within the community.
Yeah, well, my question was justified because sometimes when we talk about the whip, we talk about the fuete. People think that going to jail is the worst punishment because they have to abandon the community, and They prefer physical punishment to abandon the community. And this, in other terms, is what you are saying, that abandon the community could be a bad solution, and they prefer to be in the community, although they be in custody or they be in certain limited freedom. This is your solution. This is your intercultural interpretation.
Yes, what I'm saying is that it needs to be there needs to be a conversation between the authorities in the community and the authorities or the judges or the judges who take the decision finally in pretrial detention, because it is a very special moment of the criminal procedure, because you are not saying that this person has committed a crime. You're just investigating. So if you're just investigating, you can't just put this person in prison with all the bad things that can mean to the community and the person.
Yeah. Okay. Thank you. I think it's clear. Thank you for your explanation.
Thank you.
Okay, then let's go with Giselle and Emerson. I have a question for you. Two questions. Well, first, I'm going to make some points, some theoretical points that I think are interesting for the question. The first one, you talk about Nussbaum, and it's interesting. Nussbaum has a distinction. She explains that Kant talks about the characteristics of being a human is rationality and autonomy, and for Nussbaum, that for Aristotle the characteristics of being human is to feel pain and pleasure. In that sense, you seem to adapt this Aristotelian approach to conceive your theory and to apply your theory, and you apply this criteria of feel pain and pleasure in order to determine that animals and humans has no clear distinction. Okay, I have two questions. What happens if the animals cannot feel pain and pleasure? And the second question is more controversial. What about traditions that consist in that animals feels pain and pleasure? I think you have talked about this and the regulation in Brazil, but I want that you clarify this point. If a tradition that people considers own or feel as own stuff, or it consists in an animal feels pain, what do you think about?
Thank you, Professor. I will start answering your questions, and then I'll pass to Emerson. I know that this is a very controversial issue because basically we divide the animals between the invertebrates and the vertebrates. But we here choose to adapt our theory to the vertebrates and also highlighting the sentience as a criterion, because most of the stray animals in urban areas are vertebrates and so sentient. Although I do believe that the invertebrates should have the protected too, at least. And the second part, I would say, nowadays we don't have a specific regulation in Brazil for the animals that doesn't feel pain or pleasure. Our constitution in the article 2225, as was presented by Monique, and the colleagues stated that we have to protect fauna and flora despite of this criterion of pain and pleasure. But in fact, the regulation is more for those that feel. And I would say that this happens because the vast majority of the animals that is used for scientific experiments, entertainment, and I strongly disagree with this, but it still happens sometimes, and also farming, they are vertebrates and so sentient. But in this regard, specifically about those that doesn't feel pain or pleasure, I would like to highlight the egalitarian biocentrism that is an aspect of the biocentrism that states that all forms of life should be valued in themselves, like the reverence for life ethics or the respect for nature ethics. According to them, the requirement would be only life, not the ability to feel pain or pleasure, to feel anything. And about the invertebrates that usually are the most sensitive issue because usually they don't receive this kind of protection. We basically divide them between the inferior and superior. And in United European Union, there is a directive you're probably aware of that protects the cephalopods, but still the decapods are not under this protection. There is also movement about the crustacean compassion to regulate and to protect them, but still it is a sensitive issue. And just to finish this part, there is a great philosopher here in Brazil called Carlos Naconesi that wrote a paper in this respect titled Animal Ethics or an Ethics for Vertebrates. There's an animalist, also understate speciesism. So I know that it is a sensitive issue for those animals that doesn't feel pain or pleasure, and I would like to actually thank you, appreciate your question. I'm very thankful for that because it's in a space like this that we are able to debate and to talk a little bit more about this. Thank you very much. I hope to fulfill your the first part of your question. And the second part, I will pass to Emerson. Emerson, it's up to you.
Thanks, Giselle. If Professor allows me, I'm gonna talk about two questions about the theme again. The professor Homer Holston has a book called Environment Ethics by Sample University Press. And then this book, he said that the parts of pleasure, pain, interest, health, and other aspects of the animal rights is a part of ambiental ethics, but it's not environment ethics only the measures. The problem about recognizing the animals as subjects is not because they feel pain or because they feel precious. It's about to recognizing the life as a center of a new ethical. And in this new ethical that human being must have, we protect and promotion those animals, not because they have feelings like the human being, but because they have life, like the human being and the other spice than this word. The question was about the second part.
Sorry, the second part was about the traditions.
Again, I'm gonna minority here because it seems to me the protection animals in Brazil have a historical of protect them as objects, not as a person, not as recognizing her whole in the nature. And so even the decisions about vaccinada that the other colleagues bring here by the Supreme Court, for me, do not mean a changing, really and truly a changing about the protections of the animals in Brazil. Appears to me that we still have a traditional role to those animals that is refer them like objects, and even in the vaquejada vote, I see that the ministers didn't recognize them as subjects, but again as an object of promotion by the law, by the rights, by the men. And I think that we have in the Latin America a movement that seems more consistent in protect those animals and recognize them a role as a subject. Appears to me that this construction in Latin America is more cultural and then is state and law, because the idea of Pachamama is more than a principle in the law. It's more a cultural construction that gives some repercussions very different that we have in Brazil. So for me, it seems like historical, we don't have a movement that, for me, is being recognizing the animals like a subject the way that we want. I don't know if I give you all the respect for me.
Yeah, thank you. Okay, now my question for Monique and her colleagues. Okay, you have defined animals as minorities. These minorities has rights as minorities. What is the balance between human rights and animal rights? What about human dignity? There is an animal dignity. And for example, do you think animals have citizenship rights, as Kimberly Donaldson has defended in Zoopolis? Do you agree with these views that animals have citizenship rights?
Yes, first of all, I'd like to say something. Okay, yeah, I agree that's one very important link I see between animals' rights reivindication and the human rights. It's the nucleus of the dignity. That's in the mid. That's the nuclear idea, I guess. That's the fight against violence. If we see in the, I would say, in the history of ideas of these fundamental rights, human rights, like we can see that we have degrees. We have degrees to fight against violence. First, we fight against the one kind of violence, for instance, in the French Revolution, and then after we will reach other degrees against violence. So the Kant, sorry, premises I guess they are really in the nuclear idea, in the nuclear reivindications of these animals' rights, just like we had with the human rights, for instance, after the Second World War, for instance. So, and that's one interesting also, that there are a lot of Yiddish authors that are studying animals' rights, and maybe because the meaning or the resignification of the meaning of the life must be protected itself. That's something like that. I guess that this kind of idea that maybe growing up or being developed in the last decades. And the animals are, of course, one kind of representation object in which we can, through this social representation, most because it's our environment. So this is one thing. And about the Kinlika vision, I agree. I think that we can turn the animals inside this dignity idea, this dignity concept, because it's not only the conception of dignity for the person who can express something, or the culturally expression, but it's it's again, that's the value of the life, that's in the point of this. And it's also in the political game we have in the judiciary, for instance, we can also find this value there. So I don't know what, for instance, if I could answer or not, but that's mainly the idea. And when Kinlika makes the restricts a little the minorities between the three big fields, like sexism, racism, and the other one I forgot is the ethnocentrism, and religion is inside it. There's something that he cannot look, that the other kinds of particularities that we have in other social environments. So from this point of view, I would take distance from Kinlika to say that, for instance, we have other kinds of specificities that should be considered. If we take one step behind, for instance, to see the criteria to define a minority, I would say like this, just like prejudice, the ideology of domination, and the objective itself to to get the powerful, and with the whole context of an ideology to make the other one like minor. So in this point of view, I would say yes, we can consider. I don't know if I could answer. Tell me after.
Yeah, very interesting, very interesting. Yeah, very interesting, but open-minded, very open-minded. You are very, I think, you said you are telling that animals are citizens, animals has dignity, animals have rights, have citizens' rights. Animals are a minority. Animals are within the social contract. I think this is all your speech. This is your speech.
Yeah, even because if we see historically, the minority groups, they also was voiceless. They also had no citizenship in the history. They also had no rights. They also were object of law. The slaves were also. So, Oscar.
Yeah, I want to make a point. I want to make a point connected with the previous paper of Giselle and Emerson. They say more or less similar than your argument now. They say Rawls says that in the original position, the subjects were men, were human beings, if I understand well. My point is a claim for women, because feminism criticizes Rawls because in the original position there are only men. The head of the families, there are only men. But now you are telling me that in the original position there are only human beings and they should be animals. But
yes, we can resignificate.
if I have to distinguish between animals and women, I have to tell that for me it's more important that, and from a feminist position, I am telling from a feminist position, I think is more relevant women than animals. I think for me is human dignity, animal dignity. For me is clear. I am not in your view. I think I don't share your view in the sense that human dignity and animal dignity are different things, and I think you are more Aristotelian in this point, and maybe I have some insight of the Kantian view. I don't know. I don't know if I think your position is on fashion, and everyone now is speaking and is writing papers on your view. But I think there is a difference between animals and human beings. That's my personal view. Is a academic position.
Yeah, that's the traditional anthropocentrism is specific, just like they said, vision. And yeah, okay, yeah, that's one vision.
If I can talk a little.
That's like we can debate. We can debate.
Yeah, in the history of ideas, anthropocentrism has also had its criticisms, but of course they were a minority, I would say like that. But nowadays we can maybe try to make a little better this. Just like child, for instance, child also their wishes are not considered by ordinance. Their wishes, they are quite voiceless. They also must have a lot of, they must be represented in judiciary in all legal acts, but they have dignity and then have also all rights, and so that's quite interesting. The child, for instance, yeah, okay, that's a quite long discussion, but if we say the categories of how can I say, the beings, the alive beings we have in the world, we can see that the women also, they were voiceless and they had no rights, and they were object of law some time before also, just like slaves and just like a lot of other persons. And just like in India, for instance, the castas, the very small, the lowest castas, they have no rights also. So if we go around the world, we will see a lot of human beings just like the same juridical status like animals have nowadays. So why not get developed on that?
I think Emerson wants to tell something.
Please.
No.
Cannot hear.
Activate your micro. No. Well, maybe Giselle, you want to add something?
Yeah, I would like to add. I was expecting his internet to get better, but unfortunately it gets worse. I understand your point of view when you said that there is some kind of degree, a differentiation between consider like humans and non-humans, and back at there we have probably Monique already heard about it, about Mary Wollstonecraft, when she raises her vindication of the rights of women. The first thing that comes up is Taylor mocking her, saying, well, if we grant rights to women, so we must grant rights to animals. And I agree with Monique when she says, once we women, foreigners, also Black people or any kind of slave for other regions and things, we weren't included on the social contract, and we weren't able to speak at the very beginning. And I know that at the first instance, the contractarianism and also the theory from Rawls, equity as justice, is not the most broadened one. But since all of our society is based on the social contract, and we have been making a very good progress debating this and broaden it to us, to the foreigners, to the disabled citizens that were also not included at the classical theory. We have been making progress, and we can develop even more to include those that weren't considered at the beginning, but now we can recognize that they were excluded in order to include them. So I totally respect and understand your point of view, but I would say that it's easier to broaden the contractarianism than just race and something else. And also, I really understand that now humans and non-humans should be considered in the same level, the same degree. I'm not saying this. I'm not saying this to exclude one or another, because I know that we have sensitive issues related to humans too. We debate here the other groups of minorities and marginalized groups, but as a society, and I would say we're aiming towards an interspecies society, we now can debate and start to think to consider both humans and non-humans together at the same level of consideration. Okay. That's it. Thank you. I don't know, what do you think?
Okay, then Emerson talks, and then we have the final turn with all the questions for Emerson. Is your turn.
I'm going to speak very shortly. Maybe the problem is we still try to understand dignity like a Kant idea, or like something that is coming from a person for being rational. And maybe the concept of dignity that we search is not this concept liberal and this concept like Kant say, but the dignity not based on the idea of person, who again is a liberal idea too. The construction of the person as a being apart from the state is a conception that we don't have in the states before the liberal revolution. We have the construction of this idea of person that we still want to work, and we are trying to work all the time, like a construction of this time of liberal revolution. So maybe the problem is to understand that dignity is not construction of a person who is rational, but a being. This being human or not human, this being for be a part of a nature and for be a part of a new dimension of the human soul. I think that there is the vision we must have about this. Because if you're gonna still working about roles and the original positions in this way, we're not gonna find a space, or not we're gonna find a legitimate space to talk about a protection of animals and to understand them like beings. We must be more connected to other ideas. Né? Maybe inclusive not ideas, not modern ideas, but another theories that maybe we can go back, like again, study Tomás de Aquino, again, study some other philosophers that maybe give us a new view about the protection of this minority that is the animals. Because if we're gonna stay with this conception modern, I don't think we're gonna give a good solution.
Okay, thank you. Okay, now is the turn. Yes, we have our colleague from India that wants to talk. If someone else wants to ask a question, please, now is the moment to raise your hand. Yes.
Thank you very much.
Yes, it's your turn. Ask your questions.
Yes, my submission is not question, but my humble submission. I would like to say few words. IPSA, RC, and the organizing committee deserves appreciation for a wonderful session. And I also salute to all the presenter that they have presented very amazing papers that is very useful and fruitful for the societal concern. This is my viewpoint. Thank you so much for your kind consideration and blessing. Thank you. Thank you, ma'am. Thank you so much. Okay. I am very much happy to be part of your company and learning so much from your experiences, from your ideas, interests, idioms, dialogues, which will be useful and fruitful for the scholars and students and the next generations. You really deserve appreciation and congratulations for this wonderful, amazing seminar. Thank you so much. Thank you.
Okay.
Thank you. Thank you.
Does anyone wants to speak? Any questions? All the participants wants to talk between them? Wants to ask questions between them? Does anyone wants to talk? Raise your hand. Yes, Monique.
Okay, almost everybody's silent. I'll keep on talking. So I want to thank Emerson because you could translate what I was trying to say. Thanks a lot. Because actually this is that's what I see when I see like the history of ideas. So I would say like this, it's so huge to study, but to say this in some few words, it's like a crime because we cut everything we want to say. But I see that the conception of life and then the conception to protect the life is becoming such like larger, you know. And that, for instance, I think that's also in the center of the discussion of the paper. I'm sorry because I don't know the name exactly, but the paper about the girl, I don't know if it's Olga or Vanessa, who presented now the paper about the woman and in I guess in Colombia, the indigenous criminalization of some indigenous tradition. Oh my God, the pluralism, the juridical pluralism that we had in some countries in Latin America. So this is also in the center of the discussion. Yeah, what's the dimension of life? What's the dimension of the protection of the human being? If you have this universal way of to define, and if you go to the specificities of the culture. In our Supreme Court, for instance, the staff took this to discuss, and they said, okay, we had these games here with the animals, they can be traditional, okay, that's quite interesting, but nowadays we have other kind of mentality that says that if you put the violence and the leisure, the culture of the pleasure to have these activities, if you put them two in the balance, okay, the violence, you know, cannot be an argument to keep the tradition. Yeah, that's quite interesting to see, and I guess that's also that. But in another way, that's also in the middle of the discussion. For instance, for the legal pluralism that we have in Latin America, when we talk to, for instance, the tradition, some cultural traditions for indigenous people, yeah, and other traditional practices they have here, and also in Africa, also in some other people, traditional people all around the world. So I would say, okay, but indigenous people, animals, women, what do they have in common? I guess it's this, that you have on one way, you have the defense of the value life itself, yeah, and on the other hand, you have the traditional practice. So if I would say in the original position of roles, I would say the human being in a general way, not the human being from the modern society in the French Revolution, Oscar. I would put the life in the, I would take the original position of roles, I would put life, for instance. Life and social peace, for instance. Okay, it can be utopic. Yes, it is utopic, I know, but the utopia has one important thing. That's one goal in the future. Yeah, when we want to try to go to the stars, we can maybe reach the moon. So it sounds like this. Yeah, I'm talking too much. Come on.
Thank you, Monique. I want to intervene because I want to be controversial. I want to be out of fashion. I want to be old-fashioned. I'm going to explain point of view of a Kantian view, why animals has not the same rights as human beings. So why animals are different from human beings. And the explanation is freedom and responsibility. And that's the idea. Yes, more or less what says the Kantian view is that is autonomy, is rationality, these arguments. This has a counter-argument that there are certain human beings that has no rationality, has no autonomy, and also have rights. For example, people with disabilities or children, as you have mentioned. And this is interesting because, for example, Peter Singer, a defender of animal rights, has been threatened for the disability rights defenders because Singer defends animal rights beyond disability rights, certain type of disability, certain types of disabilities. Well, okay, this is apart. The idea is if you don't have freedom, you don't have responsibility, even potentially, because you potentially, if you are children, potentially you have freedom, you have responsibility. If you cannot be capable of freedom and responsibility, you cannot be a rights, because rights are from a person who have responsibility, who have freedom. I know that I am old-fashioned. I know that this is very old. This is out of fashion, but it's the explanation. Is the explanation. You are responsible because you can freely choose something right, something wrong, and you are punished by the legal. This is connected with the first papers. You are free to if you are responsible. If your culture obligates you something, you are not free. You are determined by your culture. That's the idea. Well, what is your view?
It depends on, for instance, about the children and their responsibilities depends on the country. That's the first thing. I mean, I'm giving only examples, but that you can have right, you can define rights with responsibility, but we also can define right, just like to protect the life. That's one kind of right. The other kind of right is the right with the duty. There are two kinds of rights. And so to protect the children, for instance, the children who don't have criminal responsibility, for instance, but they also have the protection of their lives, just like women had, just like indigenous people have in our constitution. Yeah, we have some indigenous people. We still have these 3 degrees of indigenous people in civil capacity. For instance, those who cannot be criminal responsible for what they do, just like foreign people when they come to our country, they don't know what crime they are doing, so they cannot be responsible for that. And on the other hand, on the Middle Ages, you also had a lot of animals that went to the court. That's quite interesting. But yeah, you had in Europe. Okay, but this is interesting. So yeah, Emerson, please. Initially, also, please.
If you allow me to say something, the problem to know that we only have a right when we have responsibility is the problem to another questions, like euthanasia, like questions when we have a human being that don't have the form to manifestate those responsibilities. And then they don't have rights, like she said, the children, the people they are in coma, they are not the subjects when we don't see responsibility and we don't have to protect his dignity. And so the problem with recognize only the dignity of the person in the measure of she's rational and she can respond by his acts is to ignore that even persons in some states cannot do that. And the law gives the opportunity to recognize rights for them, even if they don't have these responsibilities. For example, the donation for a person who didn't even yet was born, like the Brazilian law allows. You can have some rights, you can have some obligations by the succession rights for a person that even not is living yet. Why for a person we give some exceptions, but for animals we don't? Because the problem here is again the group of beings there is in a position that the majority don't want to protect. That is the subject. It's not the idea that someone has responsibility or not. No, because the right gives some alternatives for those people. The fiction persons or the juridic persons, they don't have or they don't can manifest those decisions, but the law gives an option to someone manifest those rights, but he have the right. Because in the capital way, because in the society of capital, the person is important because the person participates as a factor of production. The person participates as a way to make money. That is the answer. So animals don't. So
okay.
Children don't.
Okay, there is one hand raised. Olga, please. Olga, put the micro on.
Hi.
Okay.
Okay, thank you. I want to thank everyone for your interesting presentations. I wanted to share a case that happened like 2 weeks ago here in Colombia. is that a judge protected a dog's right to health and ordered a health insurance company to give him medication for life. So I think that it could be very good to take this into account. I think that the world is moving towards to this kind of to considering animals like minority groups that are subjects of rights. So it's very interesting, and to unite like both of the two of the proposals. I think that culture is the subject here, because culture can be an argument for sustaining animal cruelty, but also can be an argument to protecting indigenous communities. So it's very interesting that the concept of culture, how it can be used in both ways, right? So that's all, and thank you everyone for your input on this.
Thank you. Very interesting. I don't know if Giselle wants to add something, or we finish. If there is someone who wants to add something, Giselle and Vanessa, a final talk, a final speech. Giselle?
Yeah, I would like, thank you, Olga, for your additional comment. And using this link of culture, we have recently in Brazil about something I think it was on last year. Our Supreme Court, as a group of Monique presented to, our Supreme Court said that it's forbidden for us to do the vaquejada, like this cultural manifestation, because under our constitution, it would be against the welfare of the animal, because it's cruelty. It's cruel. But under the same recognition, under the same idea that is a cultural manifestation, our parliament did an amendment to the constitution in order to grant this cultural manifestation to be to happen. So we have our Supreme Court saying that according to our constitution, this sport would harm animals, but at the same time, because it is a manifestation of culture, our parliament grants this possibility. So it's important to all of our debate here, because we have been making progress, yes, but there is so many things to debate and to delve into in order to protect the animals and, of course, other marginalized groups either from being harmed. And just to finish, I promise, I would like to thank you very much to all of you, the organizers. It was a lovely afternoon, really, and was very audacious too. And just to finish, I would like to quote Mangabeira Unger. He's Brazilian and he teaches at Harvard University. And he says that it's true that we cannot be visionaries until we become realists. However, it is also true that to become realists, we must turn into visionaries. And I would say that we are all visionaries in here. And being that said, thank you very much for all of this opportunity.
Well, thank you very much. I think it's a wonderful end. Someone wants to add something? Raise your hand. Yes, Vanessa?
Yes, thank you. What Giselle said was beautiful. I didn't want to talk after her after that, but I have to say that I do feel more aligned to your position, Oscar, it's hard for me to understand a little bit about these things. It's not something that we are talking about here in Peru at all. I do accept that in Peru sometimes we are a little bit behind, but about the comparisons between indigenous tribes, I think that it's important to acknowledge that all these minorities that you are talking about, indigenous tribes, people with disabilities, even children, they do have the possibility to speak out and to address the issues that are affecting them. No, that I do think about the example of what we call here Piasi, that are, indigenous people in isolation and initial contact. There are many in Brazil and in Peru in the frontiers. There are these tribes that we know of, but they do not have contact with other tribes in the zone. So the legislation that is for them, it's not actually with them in the conversation. I think that this would be more adequate to the examples that you are creating for animal rights. But it's something to talk about. I think that it's for me it has been great this afternoon with you and to know all of you, even though even though I'm talking to a computer. And thank you very much.
Okay, thank you very much. Yes, was very interesting, all this session. And I want to add something. I think it's very interesting from the Brazilian approach, that is the judges who are progressive and who apply these new rights for animals. And this is very interesting. In Spain, the situation is the regional parliaments has approved some laws with banning bullfighting, for example, banning certain practice that are against animals. The judges especially has not been doing special rulings against the situation of animals. And I think this judicial activism in Brazil is something remarkable, and that we have to think that it's very good, and it's something. Okay, I am in favor of this kind of new rights, but I am not from the theoretical point of view. I am not I have not thought a lot about this, but I think there is a distinction of degree between humanity and dignity. But okay, I have to think more. Probably, Monique, I have to think more about it. Okay, well, thank you to everyone. Thank you to all the participants, all the speakers. Thank you to all the viewers, all the listeners. And see you tomorrow, because tomorrow we have another session on indigenous law and indigenous rights. And well, thank you to everyone. Do you want to add something, Monique?
I want to say thank you also, because it was really, really, really amazing. It was really lovely afternoon. And yes, the judiciary in Brazil is very progressive to all minorities. Actually, the minorities' rights start to be first with the Supreme Court. I mean, first with the judiciary in a general way, and then after, maybe, who knows, one day it goes to the parliament. It's something like that. But we can talk about this after, but this is really amazing, and we have a lot of studies about this in Brazil. And that's why the social movements for us, they are very important. And that's why this informal way of producing law in Brazil is very interesting. Yeah, but we can talk about it after. This is also very amazing point to study.
Okay, then. Thank you very much. See you tomorrow.
Thank you.
Bye-bye. See you.